लॉ क्या होता है?
कह भी नहीं सकते माय लॉर्ड। और दूसरा एक और जस्ट लेट्स लुक एट इट फ्रॉम अनदर एस्पेक्ट। नाउ 1980 is when these rules were made, and when these rules were made, if I draw your attention to order 11, order 11 को जरा देखिए।
अगर हम बहुत ही पेडेंटिक अप्रोच ले
order 11 माय लॉर्ड,
ये पेडेंटिक अप्रोच ले लें, ये किसने बनाए? किसने बनाए?
सुप्रीम कोर्ट ने।
कब?
1980।
सुप्रीम कोर्ट क्या होती है? नहीं, hang on. If you go into that approach, सुप्रीम कोर्ट क्या होती है? बताइए।
All the chief justice and the judges
sitting at home. No, where? No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, here, where is the concept of an administrative thing? That administrative concept itself is created by the rules. So it surely cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I'm not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My lord, if I may.
Ji.
Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death before their appeals came up for hearing?
This is our domestic affair.
No. With great respect, my lord, it is not.
It is
absolutely not, my lord. With great respect, this is the right of the citizen. Litigants' right here.
From the executive domestic affair.
My lord, with great respect, it is not.
Resolve this.
It can't possibly.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say...
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील इज अ राइट, सिविल पिटिशन फॉर लीव टू अपील इज नॉट अ राइट है, ठीक है? अपील इज अ राइट, सिविल पिटिशन फॉर लीव टू अपील इज नॉट अ राइट. फॉर एन अपील द रूल्स प्रोवाइड 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake. But the other question would be, suppose can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose I refuse to, suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said, नहीं, हम छुट्टी पे जाते हैं, हम कोर्ट ही नहीं लगाते हैं. What will you do? Move a reference against me? That's about all. You can't compel me under any law to do that. So the object is, there has been a problem, there has been successive addition of cases. We are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है. 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000. हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, फिर हम तनख्वाह नहीं लें स्टेट से. हम जब टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है. तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं.
My lord, I just rephrase
Constitution of benches का,
जी,
इसको पढ़े ना, ये save as otherwise provided by law.
जी. So
तब तो कोई लॉ था नहीं।
जी उस वक्त नहीं था, बट ये रिकग्निशन
Law
थी कि
has
लॉ
been
प्रोवाइड
made.
कर सकता है कुछ।
नहीं, आपसे ये अभी देखें हम,
उस वक्त लॉ नहीं था।
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
नहीं, आपसे सिंपल, आर द 1980 रूल्स लॉ, कम विद इन द पर्व्यू ऑफ लॉ ऑन?
191 की डेफिनेशन क्या आप
No,
notice
Article
कीजिए?
191.
No, sir.
नो,
These are the rules.
These are the rules. The
But
language
it is-
says subject to the Constitution and the law, the
See,
Supreme
but
Court will
what is
make rules.
the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the
You mean
full
to say
court of
that
this
now
court left it
law-
open.
Now the law has been
Knowing,
promulgated and this covers under this provision.
yes, not just this provision, it is covered under 191. This only recognizes what 191 already provides.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation
In what context, my lord?
in the context of definition of law. There are two primary law and the delegated law.
My,
And delegated law includes the rules.
no, we are looking
You
at
say
it.
the Supreme Court rules are not law.
We are only looking at the language of 191. We are looking at the language of 199 and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to parliament there was a role of executive as well. That role was taken away, that role was eliminated, but the role of parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not,
language.
you have not argued on Article 142.
मैं
Because this
उसकी
is
तरफ
the
हूँ।
distribution of legislative powers.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make law. The legislative list of article, item 57. It is also related to
58.
58. उसके साथ आप 55, sorry, 55.
55, yes, it
Jurisdiction
is,
and
yes.
power of all courts.
So insofar as section 5 is concerned, it is entry 55. With respect to other provisions, it is article
And there is
191 read with entry 58.
Article 50,
Would be
sorry,
read
item
Why is
58.
it not coming under 55? It says enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up thereon of supplemental powers. So it
what
has
I
given us
submitted, sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the Recodic judgment. 6.5 billion. Isn't that a big enough mistake for us to understand?
That's exactly what I've submitted.
It's
Section
authorizing-
5 is covered under entry
So
55.
you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
You are not, please don't take questions. You just hear them, write them down, whatever.
Now, my lord, I just stick to the submission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Learned Attorney General,
जब आप देखें हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी
Yeah.
because of this case. We can hear this case for the next month.
I-
No other work will happen in the Supreme Court. If you want this system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं. Points ले हम नोट करेंगे. हम आपको सुनने के लिए बैठे हैं. आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे
My
इनको.
lord. Now, I just quickly rush through my submissions and my.
Question that in order 11, the use of the word law or the term law, you think it carries the same meaning as in Article 191?
Yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So therefore, the principle of the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been...
Or you can call it a sharing of the burden.
Sharing of the burden.
It's a huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as Section 2 is concerned.
Absolutely.
Absolutely. And because what it does is...
If I don't trust them, that's the only other way. I can't trust them.
It is in this time when we want the justice system to be more efficient. It actually helps when there are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships. And if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before your lordships under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this?
Yes, sure.
My lord, if the pendency goes down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero. But this is what is being sought to be assessed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage Parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various judgments was not done, they would have not come up with this thing. So Parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of Constitution fundamental rights in 184.3. Otherwise, it can be ultra-vires of Constitution, you do a 199.
And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law?
आम खबर दे सनियाड़ी चौंतरा गांव में सीडीए ऑपरेशन का मामला, इलाका मकीनों के खिलाफ सीडीए का ऑपरेशन खत्म हो गया। इलाका मकीन